So I've got two very obvious imaginative slides to start with. That one, the first one says who I am and what I do, and that's enough of that.
He can come to you again.
Yeah, absolutely, yeah. Late stand-in. And the second one is entitled What I Will Cover in My Talk. And what I will cover in my talk, really, there are two main areas. The first is about contested probate litigation. I'm going to talk to you about what it is, how common it is, how important it is. How do people contest a will or contest probate? What happens if they succeed, because that's incredibly important to trustees of charities, and the impact of the leading case of Eilert and Mitzen, which was a Supreme Court decision set down in March 2017, and we're going to discuss some of the issues in that. The next part of my talk will be about the role of charity trustees in litigation. What are your duties? What are the personal risks? And how you might mitigate those risks and protect yourselves, essentially. What do we mean by contested probate litigation? Well, essentially, it's a legal construct that describes when somebody, and not necessarily a beneficiary, disputes the provisions made out in a will or in an estate. In the grand scheme of things, it's not particularly common if you think about how many people in this country die, how many estates are administered every year. It's not that common, but it is actually increasing in frequency, and there are a number of factors for that. The first is really we're in a fairly difficult financial climate. People are more attracted and more likely to make claims in circumstances like that. Secondly, it's perceived that the traditional kind of family structure has evolved and changed over the last certainly 30 or 40 years. You have second marriages, third marriages. People maybe feel like they're less, that their family ties are slightly less if there are second and third marriages, and therefore they're more willing really to make claims against an estate if it's their grandfather's estate or a step person's estate or something like that. Estates over the last 20 or 30 years have really increased in value as property prices have gone up, certainly over the last 20 or 30 years. And so the pot is bigger. It's a more attractive pot. If you have a disappointed beneficiary, they're more likely to think, well, even if I only get a small percentage of it, it's actually worth it just because of the amount of money that's involved in those estates. And I think also we can blame Trump for a lot of things. We probably can't put this one on him yet, but it's a more litigious society that we live in. That's probably the American influence, but it is as it is. How important is it to charities? Well, the crucial point for you is that if an estate in which your charity has been left a legacy is challenged, it might affect the legacy. It might also affect how you as trustees deal with that litigation that's involved. And as I'm going to talk about, you've got various duties, various risks, and there are ways, and there are things that you need to be aware of if your charity is involved in an estate that's being challenged. There are £2.8 billion worth of legacy payments made to charities every year. Now, the vast majority of that goes to the national charities, as Neil said earlier. I would hope that some of it is filtering down to you. I suspect it's more on an ad hoc basis, really, rather than, you know, kind of the concentrated campaigns that Neil was discussing with the national charities. But hopefully, you know, your charities are seeing some of that money. And really, you need to be aware of the potential effect on the charities and on you as trustees. So how do people contest a will? Well, there are four main methods. Lack of consent or lack of capacity, and that essentially is where the testator, which is the person that's making the will, lacks the requisite capacity within the tests laid down in the Mental Capacity Act 2005. And it essentially means that if they do make a will, they don't have the capacity, then their will becomes invalid. It's incredibly difficult to succeed in a challenge to a will on the basis that somebody has lacked capacity when they made it. You need, if somebody is going to bring such a claim like that, they will need lots of documentary evidence, including medical records, GP records, anecdotal evidence, witness evidence, and things like that. Next, we have undue influence, and this is where it is said that a person who either would like to benefit personally from the will, or they are close to somebody who they intend to benefit from the will, has coerced the testator into making provisions in a will that they really didn't intend to have. Again, incredibly difficult. It very often comes down to one person's word against another, and it can rip families apart. It's not really a very nice method, really, of challenging a will if it can possibly be avoided. The third, which is slightly more rare, lack of knowledge or approval of the terms of the will. This is where somebody sets out some provisions in a will, but they don't really understand the nature and effect of what they're doing. It's inadvertent. It can arise as a failure by their solicitors to advise them, but typically people say that they understand something, and in fact they don't recognise what's actually going to happen once they've died. Again, very, very difficult to challenge a will on that basis. Perhaps the most common is a challenge under the Inheritance Act, Provision for Family Independence Act 1975. This Act lays out a certain category of person that can bring a claim. They need to do it within 6 months of the grant of probate, and again, it's quite difficult for people to understand that even if they're to succeed in a claim, the chances are that they won't get very much from it. Receiving a Christmas card from your grandfather who subsequently doesn't leave anything to you in his estate, and just putting a tenner in there doesn't really get you millions at the end of the day. And people, when you explain that to them, then they don't seem to understand that quite as readily as they should, let's say. The provision under the Inheritance Act that provides for people to be able to challenge a will is that the will doesn't make reasonable financial provision for that particular person. And lawyers love that word, reasonable. It's a fantastic word because it gives rise to a whole load of arguments, and without it, I suspect that we'd be a lot less busy than we were. And I think one of the cases that really illustrates the point about reasonable financial provision is Eilert and Mitzen, which I'll come on to in a little while. Now, trustees in charities need to be aware of what would happen if a challenge to the will under any of those four methods succeeds. And the reason is that under the first three methods, so lack of capacity, undue influence, and lack of knowledge, the will is held to be invalid. The estate is then administered in accordance with the previous valid will. If there's no valid will, it goes to the intestacy rules, and to be honest, there's a jar of snakes if anybody ever wanted to see one. But you need to be aware that if the previous will or the intestacy rules do not provide for the charity, your charity, to inherit, you need to work out what your strategy is going to be as trustees when you're faced with this kind of litigation. If you support the application to make the will invalid, then you could be cutting your own noses off to spite your faces, essentially, because you might end up with nothing. If you support it, what happens then? Would you have some reputational damage to the charity? There are a lot of different things, different factors that you really need to be aware of. The Inheritance Act, if a challenge to the will succeeds under the Inheritance Act, then the terms of the will are essentially redrafted, and to make reasonable financial provision for the successful person that's complained about the will. Again, if your charity is to receive a legacy under that will and it's changed, that will affect the amount of the legacy that your charity will receive. So the leading case, as I said earlier, is a case called Eilert and Mitzen. It's worth recapping the facts very briefly. Mrs. Melita Jackson died in 2004. She left her entire £486,000 estate to three animal charities, Blue Cross, RSPB and the RSPCA. She didn't leave her daughter, Mrs. Eilert, anything in her will. Mrs. Jackson and Mrs. Eilert had been estranged for about 30 years. They really didn't speak very much. They probably didn't like each other. Mrs. Eilert contested the will under the Inheritance Act, and it went to the county court in 2007. And she was awarded £50,000 because the district judge in the county court decided that there hadn't been reasonable financial provision made for her by her mother. There was a whole load of toings and froings between the various courts on various boring legal technicalities that I won't raise today. It eventually found its way to the Court of Appeal in 2015, and the Court of Appeal decided that Mrs. Eilert should receive £163,000. She took the £163,000 and went and spent it, as you do, and it subsequently found its way to the Supreme Court, and the Supreme Court held in 2017 that actually reasonable financial provision under Mrs. Jackson's will should be the £50,000. Obviously, Mrs. Eilert had gone and spent the £163,000, but the three charities being the size that they are, and the three charities being more interested in the principles of whether they could challenge wills and what reasonable financial provision was, came to some agreement with Mrs. Eilert, and I suspect the reports were that she got to keep all of the £163,000 that she'd previously been awarded. But it just goes to show really that the national charities, Blue Cross, RSPB, RSPCA being among them, they were able to ride out a whole load of really bad publicity that came their way as a result of this. In the grand scheme of things for them, they have tens of millions of pounds coming in every year. £163,000 was only a drop in the ocean for them. I suspect that for certainly the majority of the charities that are represented here today by you guys, that's probably not the case. You're not going to be able to write off that amount of money. So again, you have to be careful about what's involved, how you deal with claims that are made against estates that your charities would benefit from. So how did solicitors react to this? Well, we had a field day, to be perfectly honest. I think every firm of solicitors up and down the country had press releases that were ready to go. As soon as the Supreme Court decision came out, people pressed send, and everybody's inboxes pretty much were inundated with these press releases and commentaries on how this case had gone, and the effect on how it was, the effect on beneficiaries, the effect on everybody who was interested in making a will. The media also had a field day. I'm not a bully by nature, but I will pick on the Daily Mail because frankly they're an easy target, and when I was looking for headlines I knew that I could go to the Daily Mail and I could find some very salacious headlines about the Eilert and Mitson case. So I'll read you a couple of them. These are probably some of the least hysterical. The first is, and I'm quoting, "Woman who was cut out of her mother's will out of spite loses 10-year court battle with animal charities." The next one is a beauty. "The dirty tricks used to stop a daughter overturning her estranged mother's will, colon. Woman's 12-year court hell as charities use surveillance, secret filming and faceless accusers to stop her getting a penny from the £486,000 estate." So, fantastic, great. Reputational damage there for all three charities, but again, as I said, they're able to ride it out because they're national charities and people leave the money whatever. So what's the nature, what's really the effect of Eilert and Mitson? Well, to be perfectly honest, we really don't know. People had a field day right at the beginning. It's kind of died a death, but I think the lessons that we all need to learn from it are that people are more aware of what they can do with their money. If it did nothing else, all of those salacious headlines, and if people read the articles, which they would have, they'd have been raised the issues about who you can leave your money to and how to protect yourself if you don't leave it to family members and people that are close to you. For trustees, it probably means that you need to be aware of these issues, if only because your duties as trustees dictate that you have to be aware of them. And I'll explain that now. So what are your duties? Well, in terms of litigation, and I'm talking about non-charitable litigation within the purposes of or within the meaning of the Section 115 of the Charities Act 2011, they're largely common sense. So we're talking about litigation that's contested probate litigation, non-charity administration litigation. The duties really are to act in the charity's best interests when bringing or defending claims. Again, you need to, I'm going back to the point about you need to know what the effect of, for example, a successful challenge to contested probate litigation will be. Will it go back to a previous will? Is it going to benefit your charity if you support that application and then you end up with nothing? Probably not. It's probably not in your charity's best interests. Protecting the charity's assets. This means that you might actually be under an obligation to support a claim. Conversely, you might find that a previous will benefits your charity even more, so you might want to support a claim that is seeking to make the will invalid. You know, these are the kind of points that you can't just go into this blindfold if you're a trustee and you're faced with litigation, or you're an estate in which you're involved in litigation. To spend funds only in carrying out the aims of the charity, you have to be aware of the cost of going into litigation. I'll talk about it in a little bit more detail shortly, but it's a very high cost. You also have to be aware of the fact that if you lose, your charity might well face having to pay the successful party's costs. To take and consider legal advice, well, it's advice generally. As trustees, you're under a duty. If you don't know everything about something you're faced with, you're under a duty to take appropriate advice. As Neil said, it could be financial advice, it could be advice from a surveyor. We're lawyers, so the relevant thing for us is whether you take legal advice, and arguably you'd be under a duty to do so. Trustees need to be aware of the implications of litigation, the implications it will have on your charity, the implications it will have on you as trustees. There's a significant financial cost in any, well, if any of you have instructed solicitors, whether in your personal capacities or as trustees, you'll know that our bills aren't particularly popular. But I can promise you that if you're involved in litigation, then they're significantly less popular. Even a relatively simple claim, if it goes to trial, could cost somewhere between £30,000 and £40,000, plus VAT, plus disbursements. Even if you're successful, your charity's successful, you will not get 100% of your outlay back. It's very difficult to work out how much you'll get back, but we work on the basis it's somewhere between 60 and 80%. So on £40,000, you could be losing somewhere between £10,000 and £15,000. Something really that you should be taking into consideration when you're considering what strategy you're going to adopt, if any. The time involved in litigation is vast. You have to decide as trustees whether that's time that you and volunteers and other officers in the charity, whether that's time that you could be better used doing something else, fulfilling the aims of the charity. If you're involved in litigation, there are meetings, there are documents, there are internal meetings where you need to decide what you're going to do. And this is without, and if it gets to trial, you could have a 2 or 3 day trial where you need to sit in a very uncomfortable seat in the back of the court following things. You need to be aware of how much time is involved. Reputational damage. We touched on this earlier. Those national charities in the Allerton Mitson case, they could ride that out because they're massive, they're huge, they can just ride it out. Could your charity ride something out if a decision went against you? What would the effect be of an adverse decision on what you do in the future? Litigation is stressful. I get paid for it, so it's part of my job, the stress. As trustees, you're volunteers. It's not part of your job. I've been involved in a few trials in my career, and I can honestly say I've hated every single one. They are really, really stressful things. Do you as a charity and you as trustees personally really want to put yourselves through that? I hope I'm not arguing myself out of work, but it's something that you really need to be aware of. As trustees, assuming you're not in a non-incorporated charity, certainly financially, as trustees you carry risk, personal risk. You can be held personally responsible for the adverse consequences that flow from litigation if you've exceeded your authority. I'd suggest that if you do act within your authority as trustees, you take appropriate advice and you ensure that your charity remains solvent at the end of it, then there's really not very much that can come back on you personally. But if any of those factors aren't the case, then you are at risk. You could be liable personally to pay damages if your charity's on the end of a successful claim. You might have to pay the charity's costs if your position, whether you're bringing a claim or defending a claim, is unsuccessful. You might have to pay the successful party's costs. You really do need to be aware of it because, as I said, the costs are substantial. If you do something really terrible, you might be debarred as being a trustee. That's something that comes down to your personal reputation. You need to work out what the risks are to you and work out how to address them, how to protect yourselves. So how can you mitigate your own personal risk? Well, the first thing to do is to be aware of what the potential risks are. It's only then that you can protect yourselves. Secondly, always act within your authority. Where you have decisions made at committee level or in trustee meetings, any discussions, any decisions made really should be minuted, they should be recorded, and they should be agreed and signed off so that you can show that everything that you have done was ratified by your fellow trustees. Only then can you be protected. You need to be aware of the risks in litigation. You need to be aware of the costs. You need to be aware of the personal reputational damage that could happen to your charity or to you. Take advice, not just legal advice, but where it's appropriate, any appropriate advice, take it. If you can show that you've taken that advice and you've either followed it or you haven't followed it for very good reasons, you're protected. Contact the Charity Commission. They are really good. Their guidance on their website is really, really very good. They have guidance notes which are very clear, probably not as concise as you'd want ideally, but they're very good. They're not too long-winded, and they're really good. Pick up the phone to the Charity Commission as well. Again, they will help you over the telephone. They're very, very good. There's indemnity insurance if you're really, really worried. If you did a Google search, you'd find some indemnity insurance providers. It's freely available, although obviously there is a charge. And if you're really, really desperate, you're very despondent at the thought of it, you can always call us.